Hello everybody. Hope everyone is doing okay and surviving. I know, a lot going on. I have an update on the Pinkava case out of Illinois. Now these records will be available to the public because the court is redacting the names, so we can release these, and I will put a link down below in the description and pin it at the top of the comments. If you want to go grab these documents, they will be on our website. And I want to thank our source in Illinois so much, sweetie. My goodness, this was a lot to read through, and I know you have a family to take care of and working full-time. I swear she's Superwoman or Wonder Woman, but thank you. We appreciate it so much. And then the comments that, she's written out to help me, a layman, understand these. So thank you. We appreciate it so much. My goodness. And so I'm going to read, her summary, since she has the legal background and not me. Because there are the pages involved in all of these documents. There's no way that I could comment any better. I just can't, because I don't understand a lot of this legally. So that's why this is great. So I'm just going to read her summary. Due to a change in Illinois law, pleadings filed in sensitive cases, such as cases involving CSA, will now be provided to the public in a redacted format where the names of the individuals in the case are not disclosed. Because we have been following this case for quite some time and will continue to do so, we have a reasonable idea of who is being referred to in the documents we have received from the circuit court. And I have to apologize. I have new glasses and they're great for close-up work and reading, but the distance from my computer screen, it's just a little bit blurry. I can, enlarge it here. Hey, that helps. All right. For those who are just learning about the Pinkava case, the state brought separate complaints against two different Jehovah's Witness elders, Michael Pinkava and Colin Scott, for failing to report to local authorities a CSA case involving the victim who was being abused by her father and who was only 6 years old at the time. But because the cases are about the same matter and the defendants are connected as they were elders in the same congregation and members of the Judicial Committee who originally heard the CSA case against the victim's father, and in order to save time for the court and expenses for the defendants, the court approved hearing both of the cases at the same time and allowed the attorneys for each defendant to file pleadings on behalf of their respective clients, which pleadings may be joined by the other defendant. The attorneys for the defendants continue to attempt to convince the court not to divulge certain information relative to these cases, alleging that the information is clergy penitent privilege. And we know, Watchtower is going to try everything they can to get out of this. Defendant Michael Pinkava was an elder in the Crystal Lake Spanish congregation, but recently switched back to his former congregation, the Crystal Lake English congregation, where he is currently an elder. Colin Scott is still an elder in the Crystal Lake, Illinois Spanish congregation. As we mentioned previously, the third elder who was on the Judicial Committee relative to the father's confession of abusing his daughter is now deceased. His problems are done. On January 5th, 2022, defendant Pinkava's attorney filed a motion for preparation of a transcript of closed proceedings and protective order, which requested that defendant Pinkava be permitted to obtain a copy of the transcript of the hearing held on December 17, 2021, and requested that certain testimony in the closing arguments be sealed. On January 7, 2022, the court entered an order allowing defendant Pinkava to obtain a copy of the transcript and closing arguments and that those transcripts be sealed. We were able to obtain the transcripts of December 16th, December 17th, and December 23rd, 2021 hearings because we ordered them prior to entry of this order. However, we will not release them to the public. On January 6, 2022, the state attorneys filed a motion to admit statements of, name redacted, but we believe it refers to the victim's mother, and the confession of name redacted, but we believe it refers to the victim's father, the state attached to its motion the following exhibits: a copy of a typed, updated statement from defendant Penkava, which we believe is a statement provided to the service department after the Judicial Committee meeting and advised that it was decided to simply reprove the father and place congregational restrictions on him. And at the bottom of that statement it says, no member of the congregation knows about this matter. Comment: business as usual, keep it quiet. You've got that right. A copy of the September 26, 2006 response from the Christian Congregation of Jehovah's Witnesses, which states, in part, that an adult who falls into the sin of CSA reveals an unnatural fleshly weakness. That's Watchtower's mentality, and some we see today. And that experience has shown that such an adult may well molest other children, but that, bold print and underline, neither the local congregation nor any legal corporation used by the Jehovah's Witnesses should be seen as an entity that has delegated authority or status to a person known to have indecently abused a minor. Comment: another statement emphasizing protect the organization, not the victim. Exactly. Kill the messenger too. A copy of the written statement given to the Crystal Lake Police Department on October 29, 2018, which, based upon the address shown and the date of birth of the person making the statement, appears to be a statement from Elder Colin Scott, who is the defendant in the sister case to the Penkava case. Because, like she said, they're blending these two for time and money, that type deal. A redacted copy of an excerpt from the transcript of the October 22, 2019 McHenry County Circuit Court hearing in the father's case, which transcript includes statements from the victim's mother and statements made by defendant Penkava. A copy of Chapter 14, Maintaining Peace and Cleanliness of the Congregation of the Watchtower Organization publication, Organized to Do Jehovah's Will, and a copy of Chapter 12, Determining Whether a Judicial Committee Should be Formed, Chapter 13, Pornography, Chapter 14, Relative to CSA, and Chapter 15 from the Watchtower Organization publication, the 2019 Shepherd the Flock of God book. In the portion of the transcript attached to the state's motion beginning on page 44, defendant Penkava stated that the congregation elders met to discuss how we could handle the CSA situation scripturally and what help we could give to the alleged sinner. Comment: scripturally, help the alleged sinner, no consideration of help for the victim. Typical. In 2018, 12 years after the CSA began to occur, when the victim became an adult, she contacted local authorities to report the CSA, at which time defendant Penkava was contacted by the local police and provided a written statement relative to this matter to a detective at the Crystal Lake Police Department. The Judicial Committee decided not to disfellowship the father, but to simply reprove him with restrictions. Typical. Beginning on page 51 of the transcript, defendant Penkava stated that as part of the reproof of the father, certain congregational privileges were taken away from him, such as handling the microphones during the meetings, directing any time of congregational activities such as cleaning, and any departmental privileges. Yeah, just a slap on the wrist. Defendant Penkava stated on page 52 of the transcript that the father could be in contact with anyone in the church. He was not restricted from contact. But that in the statement provided to the Crystal Lake Police in 2018, he apparently wrote that the father also was not to be alone with any children in the congregation. On page 54 of the transcript, defendant Penkava was asked, how was it monitored that the defendant would not have any contact with children? On page 55 of the transcript, defendant Penkava answered that the elders had the opportunity to talk with family heads of children to give them advice to not let their children be alone in this father's presence. The purpose of the state's entry of this motion was to convince the court to admit any as evidence the father's confession and statements made by the victim and or her mother in the cases brought against both elders. These elders claim to be clergy in their pleadings and as such have asserted the clergy penitent privilege. Privilege as a reason that these statements should not be admitted. As we learned in December 2021, the court ruled that defendants Pinkava and Scott were both clergy for purposes of Illinois law and therefore they are subject to Illinois law. The state's motion states that despite learning of the abuse, neither name redacted, but we believe it refers to either Elder Colin Scott or to the deceased elder, nor the defendant Pinkava, reported the abuse to the Illinois Department of Children and Family Services, although the elders were required by Illinois law to do so. And I've covered that, several videos back in that. It appears that the statement signed by defendant Pinkava was what was sent to the Christian Congregation of Jehovah's Witnesses advising that a judicial committee had handled the CSA case. It's been handled. That the father had exhibited repentance. Oh, he's repentant. And the elders publicly reproved the father with restrictions, which included no participation in a theocratic ministry school and commenting at meetings. Oh, big deal. Like that's any kind of punishment. The response received from the Christian Congregation of Jehovah's Witnesses stated, among other things, that the father should not be offered any particular responsibility in the congregation. Well, at least they did that much. That children not be allowed to spend the night at the family's home or go out in field service or cultivate friendly relationships with the father, and that he not be allowed to go out alone in the field ministry. Comment. You have to ask yourself, who's knocking at my door? A Jehovah's Witness who has committed a serious crime about which the authorities were not alerted. Exactly. Exactly. We just don't know until something is exposed, do we? The state's motion went on to say that due to the failure of the defendants, Michael Pinkava and Colin Scott, to report the CSA to the authorities, the CSA of the daughter escalated and continued unimpeded through 2018. Approximately 13 years in total. Comment. I have wondered if the elders in the congregation knew this crime was continuing. How could they face this child at weekly meetings? They have no conscience. They're sociopaths. Or psychopaths. Either one. In the state's motion, reference is made to the Watchtower Organization book, Organized to Do Jehovah's Will, and a statement from that book is quoted which reads, relevant to gross sins such as adultery and CSA, that the primary endeavor of the overseers is to restore the wrongdoer to spiritual health. Just move along, move along. Okay, we know about it. We forgive it. Let's move along. See? Comment. Not to help the victim or report serious crimes such as CSA to the local authorities. Yeah. Comment. As we all know, this is all about the Watchtower Organization keeping its clean image with absolutely no regard for, no conscience relative to, the victim of the serious crimes committed by members of the organization and the emotional scars those victims will live with for the rest of their lives. And the family. The family's devastated. Because elders must obey every directive of the Watchtower Organization lest they experience the consequences, including disfellowshipping. Oh, we know about that, don't we? For their failure to obey the organization. Many of these offenders are still out there in the public. Absolutely. Absolutely. All right. In its motion, the state also referred to that portion of the 2019 Shepherd the Flock of God book, and specifically Chapter 12, stating that it sets forth the Jehovah's Witness confessional process in a way that is not nearly as all-encompassing as Mr. Miller's description. Mr. Miller was the attorney from the Watchtower Legal Department sent by the Watchtower to testify in the Pinkava case. The state also referred to Chapter 14 of the Shepherd Book, stating that it details the way elders should respond to CSA, stating that while the victim and the parents or anyone else who reports such allegations have the right to report the matter to the secular authorities, elders, upon establishing an instance of CSA, must contact the service department, i.e. the corporation, going by the name of the Christian Congregation of Jehovah's Witnesses, for direction regarding imposing restrictions on the offender. The state's motion went on to state that specifically and in a way that suggests Jehovah's Witnesses are well aware of the ongoing danger a child abuser poses, even after the spiritual counseling and reproof. Chapter 14 states, among other things, that the service department will direct the elders to inform family heads of minors within the congregation of the need to monitor their children's interaction with the individual. A lot of times they don't. The state went on to say that the clergy penitent privilege only protects clergy penitent communications. It does not protect information acquired by a church as a result of independent investigations, not involving such confidential communications between the clergy and the penitent. In the fact, People versus Campobello case, in the numbers, portions of which were relied on in pleadings filed by defendant Pinkava's attorney, but without disclosing the full court decision in this case, which would have actually had a negative effect on Pinkava's defense. So that's same thing. They're cherry picking, trying to defend, these elders. Oh my goodness. The court ruled that the clergy penitent privilege does not protect any information that a religious institution acquires independently of a communication that is privileged by Section 8-803, even if that information is the same as that conveyed in the confidential communication. The state's motion further stated that the defendant's contention that it is merely the prerogative of the Jehovah's Witnesses to self-delineate the clergy penitent privilege is a distortion. See, they think they're above the law. And that while Jehovah's Witnesses have their own confessional process, the breadth of the clergy penitent privilege is defined by law, and it cannot be encumbered or broadened by the defendant's attempt to graft on their own religious dogmas and practices. And that under the law, the clergy penitent privilege explicitly and only protects the confession or admission of the penitent confessant. Illinois law does not protect any and all statements made during the course of subsequent spiritual counseling. The state also went on to state that although the daughter would be the one bearing the scars of the defendant's sin, any statements made by the victim or her mother were not clergy penitent privileged and could not be suppressed in this case, but should be admitted. Good. The state went on to say that if the court were to accept the defendant's position relative to its claim of clergy penitent privilege, such acceptance by the court would constitute a categorical change in the nature of the privilege and expand it beyond anything that has been contemplated or sanctioned by an appellate court. Comment. Many believe that the Pinkava and Scott cases are important precedent-setting cases, and I agree, because we've talked to some PMO elders, and they're scared. They're scared because if they have not contacted the authorities in the past, they're afraid the same thing's going to happen to them. That any time, the cops are going to show up knocking on the door. The following statement by the state really sums it all up. Surely the court can see how permitting religious denominations, some having less than reputable histories, defending the interests of children to broadly define the clergy penitent privilege in self-serving and unforthcoming ways, could substantially diminish the clergy reporting requirement and undermine the state's profoundly compelling interests in preventing, exposing, and redressing child sexual abuse, and that it would certainly be strange for the Illinois legislature to have intended that certain children receive less protection against child abuse depending on the religion in which they were born. That's the thing, is Watchtower, they're no better than anybody else. So, you know, you have to have a level playing field. On January 21st, 2022, I'm almost done. I know this is long. Defendant Pencave's attorney filed a motion to join Defendant Scott's motion to strike the state's motion to admit, and Defendant Scott's response to the state's motion to admit, which the attorney stated was filed on January 21st, 2022. However, the McHenry County Circuit Clerk advised that there was no motion filed on January 21st, 2022, but that Defendant Pencave's attorney did file that motion on January 28th, 2022. This appears to be just another mistake by Defendant Pencave's attorney. And we mentioned before, he's not the best. You know, basically a moron. Good. Good. Because his ineptness will get Pencava, I hope, prison time. On January 26, 2022, the court entered an order to seal the transcript of the mother's statements and to redact any judicial committee notes. On January 28, 2022, the attorney for Defendant Colin Scott entered a motion to strike the state's motion to admit statements. Name redacted, but we believe it refers to the victim's mother, and the confession of name redacted, but we believe it refers to the victim's father. In the Scott case, complaining that the state's attorney should not have been permitted to file another motion in the Pencava case, and argued that some of the exhibits to the state's motion were clergy penitent privileged communications, such as the Judicial Committee report and the written statements of defendants Pencava and Scott relative to the handling of the subject CSA case. In that motion, the court was asked to require the state's attorney to divulge how it came into possession of the report of the Judicial Committee handling of the confessional process, and the letter from the Christian Congregation of Jehovah's Witnesses to the Crystal Lake Spanish Congregation Body of Elders regarding the Judicial Committee meeting. This is the motion that Defendant Pencava joined in. This is all we have for now, but we will continue to follow and report on these cases. There is a hearing scheduled for February 17th, and trial in these two cases is set for March 2nd and March 4th, 2022. Thank you very much, sweetie. Appreciate it very much. And just on a side note, thank you everybody for, sticking with me through that, summary. There was hundreds of pages. And I appreciate, the source who gave us this, very much, because, this was a lot of work for her. This was a lot of work for her. And, but we appreciate it. And just on a side note, I just want to mention, several are asking if we are going to make a public statement about what is going on in the XJW community right now. Do a video. And, we've been thinking about it for several days and, tossing a few ideas around. And I got an email from a very wise person, and I forgot to print the email up, but it was something like, Kim and Mikey, your silence is more deafening than Mikey doing a rant, we told you so. And it's like, that was profound to us. It's like, yes, our silence is more deafening than any rant, we could do. We told you so. So our silence is deafening. We had our say for the past 8-9 years, and we've been beat down. And at this point, we just don't know what we're going to do or say. And that's all I know. So thank you for watching, and you all have a wonderful weekend. Bye.